from the 8th Judicial District Court of Bandera County, Texas. Ms. Kyla Green, would you please begin the announcements? And for those who are not familiar with the process, I'm going to have your attorneys announce, and then the attorneys, would you please prompt your client to announce? That'll get us through the announcements pretty cleanly. Ms. Kyla Green, would you please begin?
Yes, Your Honor. Good morning. Emily Kyla Green, attorney for the department. Ms. Peterman, please.
Ashley Peterman, investigator with Child Protective Services.
Jamie Dresden Mitchell, investigation supervisor.
Patrick O'Field, attorney for the intervener. Kim Martin's my client.
Good morning, everyone. Kim Martin.
Thank you.
And who's the gentleman with you?
My husband, Rodney.
Okay, sir, if you could announce as well, please.
Rodney Martin.
Thank you.
Irene Acosta, attorney ad litem for Andrew Lester. Mr. Lester, can you announce, please?
Deborah Fuller, attorney ad litem for the children, Kennedy and Kai.
Goldie Rapson, Hill Country Casa, guardian ad litem for the children.
Thank you. We are here for an adversary hearing today. The parties have had a little over an hour to confer. Where do we stand, Ms. Kyla Green?
Your Honor, the parties are going to request and all agree to a reset of the 262, an extension of the emergency orders, and the parties request a pre-262 mediation order.
Do you have a mediator picked out?
Well, Judge, if I could interject, I haven't agreed to the resetting of the case. I would like to still move forward today. I think we have some issues that really need to be addressed. We are set today for obviously the adversarial hearing, but also the temporary hearing on the intervention. We got 2 kids placed in foster care, a grandparent wanting to ask for custody of those children. We would think the sooner that could be acted upon, the better. In alternative, if the court feels that we don't have enough time today, I would at least request that they be ordered a visit to go with the grandparents immediately till we can have another hearing on this case. We have kin that are willing to place them. I don't believe anybody has any issues with them even having custody about what that looks like, but it's something we'd rather address immediately. But my preference would be to have the hearing today if possible.
And Your Honor, we were very close to an agreement. I think that the mediation would help us hammer out the details of exactly what's going to happen. My client's not opposed to the children going with the interveners. It's just figuring out exactly what that looks like for this case is what the issue is.
If we can, oh, sorry.
That's okay.
And I think it would be in the best interest of the boys to be with the grandparents. I know if they go on a visit, it technically, I don't think violates ICPC. I know that is something that we're trying to avoid. If we can have an agreement between the interveners and Mr. Lester and the department being dismissed, that would be, I think, the best solution for these young boys. They're suffering right now. They're having nightmares. They're going through a lot. They need to get help. They need to be with family. I watched a visit between the interveners and the boys, and they were excellent with these two young kids. They were really they addressed all their needs during the visit. They were able to communicate with them, and they were totally appropriate. There's a sibling that they already have in their home, an older brother who was not your typical 14-year-old. He was there playing with his little brothers, and he was not on a cell phone sitting in a corner like most teenagers. He was very active with these 2 little boys, and it was hard to see them not be able to go with these grandparents.
Where are the children placed right now?
They're in Austin, Your Honor.
In a foster home?
They just got moved to a foster home. They were in a shelter, which was actually a big issue for me because they were in a shelter, 2 boys 2 and 3 years old, and there was 6 or 8 other children in the shelter, and they were all teenagers. Okay. And so they were only there for, they were there for 5 or 6 days, but still, that's not acceptable. They were moved to the foster home on Monday.
So, what state do the Martins live in?
North Carolina.
North Carolina. So my goal today in intervening and what I initially thought we were going to be here for is temporary orders. What I was going to be requesting of the court is that we be named sole managing conservators. with no possession for dad, not even to name the department as a conservator. If we did that, we would avoid the ICPC issue entirely based on that 2017 case out of San Antonio, and I can give the case site, but where the Fourth Court of Appeals basically said, placement is in a foster care. Foster care is defined as if the department has conservatorship and places them in a home. So we're trying to avoid that issue. My request today would, if this was Christmas and, you were Santa, would be, probably to terminate father, if he would agree to that, to allow these kids to go.
Well, I have some gray in my beard, but not that much.
Right. I think everybody's goal is, or what they believe is best for these kids is to be with their grandmother.
Well, let me interject real quick, Mr. O'Feel. I want to hear from CASA briefly on CASA's understanding, if at all, on Mr. and Mrs. Martin and their involvement in the case.
Your Honor, CASA understands that the Martins are ready to have the boys join them immediately. We believe that's in their best interest. We are aligned with everything that the attorney ad litem offered.
Okay. And this is what I'm inclined to do without getting into all the evidence. I'm hearing, I don't know if you want to respond. I'm going to give you a little opportunity to rebut, Ms. Kyler Green, if you have anything before I say anything else.
We're aligned, Your Honor, with the interveners, with CASA, with the ad litem for the children, and I mean, really with the dad's attorney as well. My concern was the court's time, which is why
Right.
my understanding we were going to move.
I appreciate that. So what I had told Ms. Greenlee when she set this case today is that if we were going to need a full contested multi-hour hearing, it wasn't going to happen today. I was going to hear from the parties and see what we could do, and I was going to reset it. If there's talk of a pre-262 mediation in this case, I think based on the circumstances and the facts of this case, which I have reviewed the affidavit, that this is a good case for pre-262 mediation. So I would find that to be in the best interest of the children. I would also, based on the ad litems and the announcements of the parties, feel that it's appropriate at this point in time to keep the children out of foster care and put them with family. I'm not hearing any concerns about the Martins at this time. However, Mr. O'Feel, I'm not ready to name them a temporary managing conservator at this point in time. I'm going to keep the temporary orders, emergency orders in place at this time. And I'm going to reset this case and order the parties to a pre-262 mediation, but I am going to order that the children be moved to the Martins as soon as possible. My understanding is under the law, the federal law, that any visit under 30 days is a visit, doesn't violate ICPC. But I also understand that I have to have the adversary hearing within that window. So I'm going to look at the calendar here and figure out when I can bring this case back for the adversary hearing. I'm going to find a date that allows us several hours in the event we need it. I hope that we don't, because I'm sending you to mediation. And based on this temporary order I'm making today, I hope we can come to a common ground. So give me about 2 or 3 minutes to check my calendar. Ms. Greenlee's out, so I need to check it myself, and we'll come back. Remember that we're on YouTube, so please turn off your video and silence your audio while I take a look. Thank you. The court is going to order the parties to a pre-262 mediation to occur prior to the reset date. The next available date I have to give the parties a few hours on this is October the 20th, 2023 at 1:30. October 20th, 2023 at 1:30. If you have a conflict on that date, you're going to have to work it out, because that's all I've got.
I'm going to be out of town, but I'll see what
Okay. What I'm going to have you all do is go to this mediation prior to that date. You're going to have to fit it in somewhere. If you all want to discuss how to move forward and maybe you can come to some kind of resolution, then I'm not opposed to moving that date. But as far as right now, that's all I've got.
So October 20th at what time?
1:30. I've got a full docket that morning in Bandera, so it's going to have to be in the afternoon. I'm going to send the children for a visit to the Martins in North Carolina, beginning now, as soon as they can get there. And I want everybody to keep in mind that that visit cannot go longer than 30 days. So you need to be working on something. Otherwise, I might have to make orders I don't want to make. And I'm going to have, is there any objection based on the orders the court is making today? Is there any objection to everybody signing the extension of the emergency order at this time?
No objection, Judge.
No objection.
Okay. Then department is to prepare the reset order and include language that the TRO is extended. The only change I'm making to that is the location of the children, and I'm not ordering them to be placed there. I'm sending them on a visit.
Right.
Your Honor,
Yeah.
can I just ask one question? We need to get the information of where the children's shot records are, because for them to get into any kind of daycare to get things done, if Mr. Lester could just either provide that to his attorney or to the court, because we have to get copies of those for the children. Otherwise, they're going to have to redo all their shots.
Mr. Lester, I'm going to ask you questions because we've got to be quick.
Yes.
Do you know where the records are?
Yes, they're with Northeast Florida Pediatrics. It's off of Atlantic Boulevard, and it's right by the Intercoastal. If you Google search it, it's right there. The doctor has like a 6-name, like Pena, Areta, something like that. But that was their pediatrician. It's got all of their shot records there.
You said Northeast Florida Pediatrics in Jacksonville?
Yes, it might be Jacksonville Beach. It's right there at the bridge of the Intercoastal. And you come
What I'm going to
over-
have you do is, if you all can see if you can find that. If not, Ms. Acosta can get more information from Mr. Lester, but that should be enough to get it for you.
Thank
Your
you.
Honor, the department is also requesting a hair follicle test for the children to establish the baseline.
I think that's appropriate considering the facts of the allegation or the alleged facts. Ms. Martin, you'll have to unmute.
We're going to need some kind of identification for the children for flights. We have no birth certificates, social security numbers, anything like that.
The department will handle their travel arrangements.
Thank you.
Ms. Mitchell, is there anything else that I need to know at this time or that you think you might have an issue with based on the orders I'm making right now?
The internet said it was unstable, so everything that was just said I didn't hear. It like
All right, well, I'm catching you up right now. Okay. Ms. Mitchell, that was directed at you. Is she frozen? No, she's there.
I'm sorry, I have a very large delay. I apologize. No, I believe that's it, Your Honor.
Okay. All right.
One clarification, Judge, that 30-day deadline would be from when they receive the children, correct?
That's my understanding.
Okay.
Is that correct, Ms. Mitchell?
I'm sorry, he broke up. I didn't hear the question.
The 30-day timeline for the visitation begins upon the receipt of the children, correct?
I believe so, yes.
Okay, thank you.
Okay. Those are all the orders I can make at this time. And Ms. Kyler Green, if you could have the assistants get that out as soon as possible. I'd like to get everybody's signature on that before we close the business today.
Yes, sir. Understood. Thank you.
All right. Thank you. Okay. Thank you all for your time and your service. Ms. Harris is with us. I'm going to allow her to keep her video off at this time. She'll turn it on as soon as she's able. Okay. Ms. Kyler Green, would you please begin the announcements? And if the attorneys would please prompt their clients to announce.
Yes, Your Honor. Good morning. Emily Kyler Green, attorney for the department. Ms. Palmer.
Yvonne Palmer, permanency specialist with Belong.
Ashley Couch, permanency supervisor with Belong.
Richard Saldivar, attorney for Mr. Keebitt. Mr. Keebitt, will you unmute and announce, please?
Mr. Keebitt, present.
Jennifer Harris, attorney for the Jennifer Harris, attorney for the respondent mother, Ms. Bindley. Ms. Bindley, can you?
Megan Bindley, present.
Kathleen Savage, attorney on line for the children. Your Honor, I'm ready.
George Dombart on
Goldie
behalf of Justin and Kathy Bindley, and they're ready to announce presence.
Kathy.
Justin.
Goldie Robson, Hill Country Casa, guardian ad litem for the children.
Okay, my understanding is that we have two motions set today, a motion for transportation and then a motion to suspend visits. Is that correct?
Yes, Your Honor.
All right. Mr. Saldivar filed his motion first, I believe.
Yes, sir.
All right. Any problem with us hearing evidence altogether as far as both of your motions?
Objection.
No objection, Your
No
Honor.
objection.
Objection.
Any other? Thank you, Mr. Delmar. Any other housekeeping issues we need to take up before we begin?
No, Your Honor.
Your Honor, just a request that the individuals remove their hats.
Oh, yes. I'm sorry, Mr. Bindley, if you could please remove your hat. And Mr. Keevan as well. Thank you, Ms. Kyler Green. Okay, then we will proceed. I'll allow Mr. Saldivar to go first and Ms. Savage to go second, and then we'll go with the department. And that's the order of questioning. So, Mr. Saldivar, you may proceed. Witnesses have been sworn.
Yes, may I call Ms. Palmer, Judge, as my first witness? And you've been working with the parents since this case became legal, is that correct?
Yes.
Okay, and as far as services, how are the parents doing with services at this time?
Currently, I would say participation is marginal at best.
Okay, marginal. Okay, and to your knowledge, have the parents had issues with transportation?
In regards to services,
Or just transportation to visits or services, anything that requires transportation, have they had issues?
they have had some issues with transportation since I've had the case, but not
Okay.
consistently.
Okay, and to your knowledge, do they have a working vehicle that they can use to transport themselves?
To my knowledge, it's been reported by Mr. Keevan and Ms. Bendelay that they do not have means of transportation.
Okay, and to your knowledge, how do they get around to the services or to the visits throughout this case? How have they been doing that?
They get to the visits usually with help of people from the church or friends in their community.
Okay, have they expressed to you that these individuals that have offered rides, they're not always available to them?
They have stated that to be true, yes.
Okay, and have the parents reported to you missing any services or visits due to transportation issues?
There has been some recent visitation that they stated was missed due to transportation.
Okay. Now, at the beginning of this case, the department did transport the parents for, I believe, hair fall. Is that correct?
Yes,
Okay. And were you there during that transportation?
yes, I was.
Okay. Were there any issues that occurred during that transportation to the hair follicle?
No,
Okay. And since then, have the parents requested any transportation from the department or belong?
yes, they have.
Okay. And has the department denied transportation, or what's the situation with that?
On the time that transportation was requested during a missed visit, we did not have the staff to be able to provide that transportation on that particular day. It was asked the day of.
Okay. Now the parents have made other requests for the department or belong to transport them. What is the position of the department on agreeing to transport the parents?
At this time, based on yesterday's meeting with the parents, Ms. Bendelay has stated that they have transportation now. So at this time, I don't believe it is an issue.
Okay. Going in the future, if that transportation agreement breaks down, will the department be willing to transport the parent or transport the parents to drug tests, visits, or services?
I would have to staff that with my supervisor.
Okay. And is
Your
your
Honor, at this
supervisor?
time, I object to the line of questioning. It sounds like he just mooted his motion, so.
Judge, and if I can respond to that, I believe the testimony that parents have requested rides from individuals. It's not always reliable transportation. And so they have found somebody now, but that doesn't mean that they're always going to be available to the parents for the multiple services and drug tests that the department's requesting for my clients.
No, I understand that. I had a similar thought to Mr. Dombard a few minutes ago. I'll allow you to explore it a little bit more, but at this point in time, time being the factor, you can go a little bit further, but I think that there is something to say for the fact that they have transportation right now. If they have the ability to get it, we can look at the future, but I don't want to spend too much time on it.
I understand, Judge. My only other question was, of course, Ms. Crouch is your supervisor. Is that correct?
Yes.
Okay. Pass the witness, Judge.
All right. Ms. Savage, we'll just go in the same order on cross as we're going to go on direct.
Okay. Ms. Palmer, in regards to the visits for, or the services for the parents, you set up virtual visits to help alleviate the transportation issue. Is that correct?
Yes.
And the respondent father has been dropped from multiple virtual providers, correct?
Yes.
Okay. Are you at a point where the Belong is running out of virtual providers?
For the drug treatment services, which are needing to be provided virtually, yes, we are. I'm not even sure if we have any more options. We've been through the 2 providers that we're contracted with.
Okay. Well, let's talk about why Dad was dismissed from those providers. Can you explain to the court why he was dropped from 2 virtual providers?
As it was reported to me.
Objection, hearsay, Judge.
Sustain. Let's prove up how she knows this information, Ms. Savage.
Ms. Palmer, are you the custodian of record for this case?
Yes, I am.
Okay. And part of your employment as the custodian of records is to receive reports from the service providers. Is that correct?
Yes.
Okay. In those reports that you received and as part of the court's record, or as part of the record for the Belong, what was the basis for Mr. Kivet being dropped?
It was reported to me that he was dropped from Mindful Innovations due to non-compliance with completing the referral process. And the same was with the AB Counseling Solutions. He was dropped for inability to complete the assessment process.
And why was he unable to complete the process?
He didn't want to answer the questions that they were asking. He felt that those answers were already provided in the OSAR. That was previously done on August 8th, and he became angry and belligerent with the providers, and that was their ultimate reason for termination.
Okay, so this happened with 2 separate providers, correct?
Yes.
Have you also received reports of Mr. Kivet losing his cool and becoming aggressive with the the supervisor who listens to the phone calls between the parents and the children?
Objection, hearsay, Judge.
Your Honor, I can go through that whole line of questioning again as they receive.
Overruled. She's a custodian. If she's getting it from her file, then it's, unless you have a hearsay within hearsay objection, but I'm not hearing that yet. So go ahead.
Go ahead.
Just in those notes that you received from the supervised phone calls, what remarks or recommendations have been made?
There was just one occasion where there was a conversation afterwards, and that was just regarding Mr. Kiva being upset that he was being told that his children didn't want a phone call that day. And so there was some exchange, and he was pretty upset that that was happening. So he did speak to the person who was supervising the call about his dissatisfaction.
Okay, and you're talking about dissatisfaction. He was upset, but was this like a rational phone call? I mean, how was the supervisor in her
speculation, Judge.
in those remarks?
Hang on, you said objection speculation?
Yes, Judge.
Yeah, rephrase, Ms. Savage.
In the notes, what was it described as? You know, a regular, he was upset. How was this phone call described, Ms. Palmer?
It was described as he was upset that on that day the visit had not occurred. And so we had done a phone call in lieu of the visit, and he was upset that he was being told that his children didn't want to talk to him. So he had made some remarks that he was going to speak to his attorney. He referred to the person supervising the call as sweetheart and things like that. And it made her very uncomfortable.
And there was another incident.
Hang on just a second, Ms. Savage. Ms. Bendeley, where are you and Mr. Kivet going?
We're at the Civic Center where we live, so we had to they're locking up the inside, so we had to move outside real quick.
Okay, well, try to get seated as soon as possible and keep your device still. Go ahead, Ms. Savage.
Ms. Palmer, there was an incident last week with another notification in the files about the phone calls, something occurring inappropriate. Is that correct?
Yes.
And can you tell the court what happened?
During the phone call, Mr. Kivet became upset with, the fact that, again, his son did not want to come to the phone. Brantley had refused the phone call. So he was trying to get him to come onto the call. And then when Remington went and got him, that's when Mr. Keevitt had made the remark that Mr. and Miss Bendeley are trying to take them from them. So that remark was made to the children during the phone call.
And then going back to the visits, the parents have, how many of the visitations have the parents attended?
There's been a total of 18 visits scheduled. 5 of the visits were canceled by the parents.
Mr. Keevitt, I need you to take a seat next to Miss Bendeley. We're in court. Okay, this is a court of law. Go ahead, Ms. Palmer.
Sure. There's been 18 visits scheduled. 5 visits have been canceled by the parents. There's been 12 visits that both parents have attended. And then there was 1 visit where Mr. Keevitt chose not to attend. So mom has attended 13.
Okay. And the visit earlier this month, on September 6th, were you able to supervise that visit?
Yes, I was.
And during that visit, were the parents engaging with the children? What were the children doing during that time?
During the visit that I supervised on September 6th, the children chose to use a pretty large amount of the visitation time to be on the computers at the library.
And when the children are made aware that visits are canceled, how is that affecting the children?
Initially, they were very upset, and most recently, they're not as vocal about it. They just kind of expect it. So they're not really showing that they're upset or anything like that.
Okay. Have you received a recommendation from the children's therapist in regards to suspending visits?
Yes, I have.
And what is the children's therapist recommending?
The therapist is
Your Honor, calls for hearsay. It would be very easy for them to bring the therapist in to testify what she wants. We don't need to go through a hearsay source.
Your Honor, she's the custodian of records for these children. This is a record within Belong's record, and the parents have all received the therapy notes from this counselor as well.
Ms. Harris, I'm gonna give you the opportunity to take Ms. Palmer on board on how she knows what she knows about the therapy notes.
Ma'am, have you spoken to the therapist yourself?
I have spoken to her on the phone, yes.
Okay. And has she provided recommendations to you by phone or by writing?
The recommendation she's provided has been by writing.
And have you been able to confirm any of the reports the therapist is making about what the children say? Have you been able to confirm those with the children themselves?
I have not been able to confirm those with the children themselves.
And do her recommendations involve things that she says the children have said to her?
Yes.
So, Your Honor, I would again re-urge that this is hearsay within hearsay.
Your Honor, she can state what's contained in the file as custodian of records, and so she can report what's been reported to her, and it was in writing, and so if Ms. Harris want to question the analysis on how she gets that recommendation, then Ms. Harris should call the therapist to the stand.
I believe that I'm satisfied with the fact that Ms. Palmer has spoken to the therapist directly, seen her recommendations. I understand the hearsay within hearsay as far as the children are concerned, but I'm not going to bring the children in here and have them testify. So I'm going to overrule that objection and allow her to continue to testify.
Ms. Palmer, what was the recommendation from the therapist?
The recommendation is that visits be suspended until parents work with their individual therapists and can demonstrate a behavior change.
Going back to the parent services, let's start with mom. When was last time the mother drug tested, or when has the mother drug tested for you throughout this case?
The mother actually drug tested yesterday. We did an oral swab following yesterday's visit.
Okay. And when you made the request for the oral swab, was she readily compliant?
She initially was reluctant and she wanted to test next week. And that's when it came up that she has transportation now.
Okay. And when was the last test before yesterday's swab test?
Before yesterday, the last test was 7/17 of this year.
And how many requests had you made between July 17th and yesterday for Miss Bendeley to drug test?
There had been 4 requests total since July 17th.
Okay. And why was Miss Bendeley unable to complete any of the other 4 requests?
She stated that it was due to transportation.
Okay. Was there any issues regarding employment or being out of the area as well?
Yes, Miss Bendeley stated that she was traveling with Mr. Kiewit for work in New Braunfels, and we offered to have them tested at the location near their work site, but they were unwilling to disclose that location or zip code for us to be able to put a test in.
Okay. And to this date, have Miss Bendeley or Mr. Kiewit provided the name of their employer?
No, they have not.
Okay. They provided an address for where they're working?
No, just the city of New Braunfels.
Okay. In regards to Mr. Kiewit, when he drug tested yesterday too, is that correct?
Yes, he did.
Okay. When did he drug test before then?
The same date, July 17th, 2023.
And how many requests for drug tests have you made to him since July 17th?
4 as well.
And why was Mr. Kiewit unable to complete any of those 4 drug tests?
He stated due to, well, Miss Bendeley stated for him it was due to transportation. I only speak with Miss Bendeley via text message or phone call.
Okay. And has there now been an issue of Mr. Kiewit not having a valid license?
That's been an issue since the beginning. We identified a testing location that will take a photocopy of his ID, and it's Care Now. So there's several locations to choose from in the San Antonio area.
Okay, so him not having anything but a paper license is actually not an issue.
Correct.
Anymore.
Correct.
Okay. In going back to Miss Bendeley, what other services has she started or completed at this time?
At this time, Miss Bendeley has completed her OSAR. She is also engaging in therapy with a new therapist.
You say engaging in therapy, but how many sessions? You said new therapist, right? So there was a previous therapist that she was seeing, correct?
Correct.
And she didn't like that therapist, so she dropped her. Is that correct?
Correct.
So she started with someone new. How many times? When did she start with this new counselor? And how many times has she seen her?
Sure. She initially was referred at the beginning of August, and she's had 1 appointment. She has missed 3 subsequent appointments.
Okay, so she's not actually engaging, correct?
Correct.
So in 2 months, she's gone to 1 appointment, and that initial appointment is usually an intake appointment.
Yes.
Okay. And she's not doing any kind of drug treatment at this time?
No, she's been referred to Mindful Innovations, and she needs to complete her assessment.
Okay. And this case started because the baby was born drug positive, correct?
Yes.
Okay. And then in regards to Mr. Kiewit, what has he done in the way of services?
He has completed his OSAR. He has completed his psychological evaluation, and he is engaging in therapy.
How many therapy appointments has he attended?
He's attended 3 sessions.
Since when? When did he start therapy?
I believe he started August 3rd, 2023 was his initial session with Patricia Boone.
And how many has he missed?
I believe he missed 1 session.
Okay. But he hasn't been able to start any kind of drug treatment because he's been dropped by multiple providers.
Yes, I need to try to find another virtual provider. The ones we're contracted with, we've unfortunately it hasn't worked out. So we need to find one, and I'm not sure if we're contracted with another virtual provider.
Okay. Will Belong be able to reunify these children with these parents if they do not address the drug issues?
I don't believe so.
Okay. And is Belong at this point looking to switch their permanency goal from reunification to another permanency goal?
Yes.
What will that new permanency goal be?
Relative adoption.
I'll pass the witness, Your Honor.
Skylar Green.
Thank you, Your Honor. Ms. Palmer, let's start with the transportation. From your perspective, is it important for parents to be able to show their ability to transport themselves and their children in the future for a case to be eventually dismissed?
Yes.
Why is that important?
Because the children will have doctor's appointments, they'll have to need to get to school. The parents will probably be needing to continue with services and therapies, and the same with the children.
You testified earlier that that Mr. Kivet and Ms. Bendeley don't work locally. Is that correct?
That is what they told me, yes.
Okay. And so have you seen or heard from the parents of any issues of them actually finding transportation or transporting themselves to employment outside of Bandera or their hometown?
From what was reported to me by Mr. Kivet, that they do have transportation to get to the job sites.
And so this request for the department to provide transportation to visitation, how do you feel about that? What is your perspective on why there's pushback from the department and Belong on that?
I feel that the parents in the beginning of the case were able to get rides and get transportation to the visitation. The visitation and the drug tests are the only services that require them to have transportation. We set them up with virtual services. So I really feel that it's important for them to continue to find transportation. And as I stated previously, Ms. Bendeley assured me that that's no longer an issue.
Okay. And so just to be clear, when you have requested for Mr. Kivet and Ms. Bendeley to attend those 4 requests, did that require them to transport themselves to the drug testing facility?
Yes, and on several occasions, I even did the testing on a day where they would be coming to the visitation.
When they had transportation?
Yes, as long as they were attending the visit, yes.
So from your perspective, is this really an issue about transportation?
I don't believe it is.
What do you really think the issue is?
I don't know that they want to drug test. There's just been some pushback with it.
Are there concerns about safety in regards to transportation from your perspective?
There has been some concerns regarding safety just based on the assessments that were provided to me, mainly by the substance abuse professionals, that Mr. Kivet just becomes very upset easily sometimes. So that's mainly the reason why the agency has had some concerns regarding transportation.
The agency being?
Belong.
Okay, so your employer and you specifically, is you're saying that you have concerns over your own personal safety?
Yes.
Okay, let's talk about the visitation. Has the permanency goal actually been changed?
Yes, for the hearing that I'll be submitting the report for the October 20th hearing, we have changed the goal to relative adoption, with the concurrent plan being family reunification.
Okay. What do you feel is in the children's best? Well, actually, let me ask you this. Have you spoken directly with the children about visitation with their parents?
Yes.
Okay. Have the children expressed to you concerns with visitation?
Objection, Your Honor, hearsay.
Well, the question was, has she spoken to the children, correct?
That was the question, Your Honor, yes.
Overruled. She can answer that question.
Yes, I've spoken to the children regarding phone calls and visitation.
Okay. And you've also spoken with the therapist?
Yes.
Okay. Have you spoken with the parents about visitation?
Yes.
Do you have concerns at this time with domestic violence in the home? Either in the past or currently or in the future?
In the past, there's some suspicion that there has been domestic violence in the home.
Is that, when you say suspicion, is that just based on your gut, or is that based on your experience with this case?
Based on the children's therapy notes.
Okay. Excuse me. In regards to future visitation with the parents, do you feel like that is an issue that needs to be addressed before the visitation continues?
I don't think that's an issue, but I'm not a therapist.
You don't think that domestic violence in front of the children is potentially an issue that would impact their visitation?
I would agree that domestic violence would be an issue and a safety concern, but that they have not talked to me directly about domestic violence occurring.
I'm not asking about an issue for the children from their own mouths. I'm asking about your perspective as a caseworker. Do you think that domestic violence in front of the children, towards the children, whatever, is an issue for children in future visitation?
Yes, I do.
Okay. And do you think that that is something that should be addressed before we continue with visitation?
Yes.
Simply because this is a new issue that has popped up in the middle of this case?
Yes.
Okay. You testified about this directly, but I just want to make sure it's clear for the record. Their OSARs have been completed. Is that correct?
Yes.
Okay. But and there have been some drug tests that have been completed?
There was, besides the test done yesterday, there was, since I've had the case, there was 2 drug tests completed, but one was invalid back on July 4th, I believe. And then we repeated that on July 17th. So those were the tests that have been completed.
Okay. We don't have the results yet back from the oral swab that was completed yesterday?
We do not.
Okay. Besides the drug tests, have there been any actual drug treatment pursued by the parents in this case?
No.
I don't even mean completed.
No, they had set up the assessments, but unfortunately, Mr. Kivitz resulted in him being terminated from 2 programs, and Ms. Bendelay has not completed any assessment appointment yet.
I have nothing further.
Ms. Harris?
Has there been any domestic violence at any of the visits? Ms. Palmer, can you hear me?
Yes, I said no.
Okay, so why would you be afraid that domestic violence would occur in the visits if it's never happened before?
I am not concerned that it would happen during the visits.
Okay. You've mentioned that there's possible drug concerns, domestic violence concerns, but are there also concerns about mental health?
Yes.
And what has Belong and you specifically done to help address those mental health concerns?
I have referred Mr. Kivit to Patricia Boone for therapy, and I've also referred him for a psychological evaluation, which he did complete. And he has also been referred for a psychiatric evaluation, which he needs to complete.
Do you agree that it's typically difficult for parents to engage meaningfully in other services if their mental health needs have not been addressed?
I could see how that would be difficult, yes.
Okay. So if you've made the referrals, is there anything else you can do to be helping address those mental health concerns? Or do you just say, here's a provider, you're on your own?
I've had conversations, again, through Miss Bendelay, because that's my only means of communication. We're on a group text, I know, with the attorneys and my supervisor. So all I can do is encourage Mr. Kivit. It's actually at his request to have the psychiatric, and his therapist concurred with that. So aside from telling him the importance of it, to give him the help that he needs, that's what I've been doing.
And even though they've said that they've got transportation now, transportation's actually been denied to them by Belong in the past, hasn't it?
It has been denied due to not having the staff.
If addressing mental health issues in this case might lead to better compliance with other services, would it not be helpful for, and because virtual providers are in limited supply, would it not be helpful for Belong to offer to take Mr. Kiewit to his appointments for mental health treatment and drug treatment?
I could see how that would be helpful.
No further questions, Judge.
Mr. Dunbar?
Yes, Your Honor, just briefly. Ms. Palmer, you had stated that the department did have some concerns about their the employees' safety in this case regarding being around Mr. Kiewit specifically, but is that correct?
Yes.
And is it correct that Mr. Kiewit has actually brandished firearms on multiple occasions to caseworkers?
That was before I had the case. That was in the report. Yes.
Okay, and to your knowledge, does Mr. Kiewit still possess that firearm?
I honestly have no idea.
To your knowledge, has anybody involved with this case confiscated a firearm from Mr. Kiewit?
Objection, relevance, Judge.
Overruled.
Not to my knowledge.
And so wouldn't it be reasonable for Justin and Kathy Bendelay to also fear for their own safety?
Objection, speculation, Judge.
In your opinion?
Overruled.
Can you repeat the question?
In your opinion, isn't it reasonable for Justin and Kathy Bendelay to also fear for their own safety, knowing that Mr. Kiewit still possesses a firearm?
I could understand why that would create concern for them.
Okay. And Mr. Kiewit specifically has a history of crimes of violence, correct?
Yes.
Okay. And in your experience, can you state a reason why somebody would avoid drug testing?
Objection, Your Honor. Calls for speculation.
Based upon your experience.
Let's rephrase that a little bit. Let's be a little more specific, Mr. Dunbar. Sustained.
Yes, Your Honor. Would a reasonable explanation be that the reason why somebody is avoiding a drug testing is because they are continuing to use illegal substances?
Objection, Your Honor. Meaning.
Overruled.
That could certainly be a reason why someone would avoid drug testing.
And the substance involved in this case that is of concern is specifically methamphetamine usage?
Yes.
And typically methamphetamine usage indicators leave the system after in a relatively short time, correct?
Yes.
So there has not been any kind of, in your experience, hair follicles and or nail samples, they do provide a more historical view of somebody's substance abuse usage, correct?
Objection, Your Honor. It's calling for medical knowledge that we don't have any evidence that she's been trained in.
Do you want to ask her about it?
Yes.
Okay.
Ma'am, what specific training have you received regarding regarding drug testing?
The only training I have received was from Belong, and I've consulted with a substance abuse specialist.
In this case specifically?
In this case specifically.
And when you consulted with the drug specialist, did you specifically speak about their drug test results?
Yes, I specifically spoke about Mr. Kiewit's drug test result.
I'll withdraw my objection, Your Honor.
All right.
So, Ms. Palmer, a nail follicle or hair follicle, a nail sample or a hair follicle sample would provide a more historical view of substance abuse and the prior substance abuse, correct?
Yes.
And has either a nail sample or hair follicle been collected in this case?
Yes, it has.
Okay. When was that done?
That was done on July 17th, 2023.
Okay. And did you receive results on that?
Yes, I did. The results were negative.
Objection, Your Honor. Objection, Your Honor. Hearsay. She's testifying to the results of a medical test
Sustained.
that she did not perform.
Sustained.
I'll pass the witness, Your Honor.
All right. We're at 12:16. Mr. Saldivar, do you have any follow-up questions?
Yes, just a few, Judge. Ms. Palmer, have you had any problems with Mr. Kiva and weapons during this case?
I have not.
And to your knowledge, has Ms. Crouch had any problems with Mr. Kiva and weapons during this case?
Not that I've been made aware of, no.
And to your knowledge, have the children expressed any concerns with weapons in the home?
The children have spoken about weapons in the home.
Okay. Have they expressed any concerns though?
No concerns.
Okay. And you said that the parents are in marginal compliance, is that correct?
Yes.
They did have a visit yesterday. How did that visit go?
The visit went well, with the exception of a few hiccups.
Okay. And can you explain what the hiccups were?
There was, Mr. Keevitt would like the Bendelays to take one of the family dogs. I believe it belongs to Brantley. So I was trying to explain to Mr. Keevitt and kind of just keep it kind of light about, well, I'm not sure if that will work, and the other dogs in the home. And he had made a remark, well, they're going to file these papers and do all these things. And I stopped him. And so then that ended and he was able to be redirected. And then again, he just about 2 or 3 times was just telling Brantley that he needs to accept the phone calls and he needs to come to the phone and that it really hurts him when he doesn't. And so I had to redirect and try to smooth that out a little bit because Brantley was being affected by it.
Okay. And when you redirected him, did he follow the redirection?
He did.
Okay. And you did ask for a mouth swab yesterday, is that correct?
Yes, I tested both parents.
Okay. And both of them agreed and didn't give you any problems, is that correct?
Yes, they both tested.
Okay. And there was a family conference held about a week or 2 ago, is that correct?
Yes.
And it was just the issues of transportation and drug testing, the concerns the department had were addressed with the parents at that time. Is that correct?
Yes.
And all the parties there did agree that the parents could do mouth swabs either before or after the visitation. Is that correct?
Yes.
And then the first opportunity that the department had, the parents did comply with that mouth swab. Is that correct?
Actually, after that family group conference, the parents had agreed to test at the next visit and they canceled that visit. So we had to try again yesterday.
Okay. What was the reason for the cancellation?
For transportation last week.
Understood. Okay. Pass the witness, Judge. Thank you.
Any other follow-up questions for Ms. Palmer?
Yes, Your Honor, just a few. Ms. Palmer, that hair test back on July 17th, did that give the department concerns for methamphetamine use?
Yes.
Okay, and that hair test back on the 17th for Miss Bendeley, she had just dyed her hair before that test, correct?
It appeared that she had dyed her hair, yes.
Okay, and then going back to concerns for the department, Mr. Keevitt in this case has gotten aggressive with a caseworker during one of the initial visits. Is that correct?
Objection, Your Honor, leading.
I'll rephrase. Do you have knowledge of Mr. Keevitt getting aggressive with any belong workers during visits during this case?
Yes, in the beginning of the case.
Okay. And in regards to the domestic violence is it always just physical or can it be other things?
Yes.
So while you don't
Yes,
necessarily
just for the record's sake, yes, it's always physical, or yes, it could be other things.
It could be physical or it could be other things such as emotional.
Okay. Go ahead, Savage.
do you have concerns that emotional domestic violence is occurring either at visitations and at phone calls?
I do have some concern, yes.
Okay. In regards to mental health needs, will the parents be able to address mental health needs if they're active in drug usage?
No.
Okay. And have you seen any signs, particularly on the mother, that would indicate to you that she is active in her drug usage? To include physical appearance.
I'm not a substance abuse expert, so I don't know if I'm qualified to answer that.
Okay. In your experience as a caseworker and having experience working with drug users, have you seen any signs on Ms. Benderly that would indicate to you that she's using?
In my experience, I have seen clients that are actively using methamphetamines, and they do have marks on their skin that are indicative of a methamphetamine use.
And have you seen these similar marks on Ms. Benderly?
I believe that I have.
I'll pass the witness, Your Honor.
Just one question, Your Honor. Ms. Palmer, how many times, if you had to guess in this case, how many times have you had to redirect Mr. Kiewit?
I would say about maybe a half dozen times.
In visits, in conversations, in...
Yes, during some phone calls that I've supervised, and then during the visitations that I've supervised.
Thank you.
Any other follow-up?
Just one, Your Honor. Ms. Palmer, based upon your observations, have you formed an opinion about whether or not you believe drug usage is still occurring?
I believe, in my professional opinion and being a permanency specialist and with my training, that I do believe that drug use has continued to occur during this case.
Thank you.
Mr. Saldivar, do you have another witness?
Just Ms. Crouch, very briefly, Judge. Ms. Crouch, you're the supervisor of this case, is that correct?
Yes.
Okay, and you have transported Mr. Kiewit and Ms. Benderly to a drug test, is that correct?
Yes, Ms. Palmer and I transported them together.
Did you have any issues or concerns during that transportation?
No concerns with the parents, no.
Okay, and have you had any issues with Mr. Kiewit and firearms?
I personally have not, no.
Okay, and how would you rate their compliance with their service plan at this time?
I believe Ms. Palmer's testimony covered it. They have done their OSARs. Dad has made 3 therapy appointments. Mom has made 1, and they have not completed their outpatient substance abuse assessments. I'm sorry, and Mr. Kiewit also did complete his psychological.
Okay, and do you believe it's in the best interest of the children to stop the visits at this time?
I believe that that is the therapeutic recommendation at this time, yes.
Okay, pass the witness, Judge.
Ms. Savage?
Yes, Ms. Crouch, would you have safety concerns for your belong permanency workers if they were made to transport these parents to and from visits, to and from drug tests, to and from services?
I think that there is an ongoing safety concern, yes. When we have met with the parents in person for family group conferences or separately in person with their attorneys, we have made those appointments at a facility where bailiffs are present.
Okay. And in that one of these conferences you had with the parents, isn't it true the parents were requesting or demanding to only be drug tested on certain days?
Objection, Your Honor, leading.
During your conference with the parents, were any requests regarding drug tests made of belong?
Yes, when Ms. Palmer and I met in person.
Continue, sorry.
Okay. When Ms. Palmer and I met in person with the parents and the attorneys, the parents did request that they not be tested on days that they have parent-child visits, as that does affect the mood that day and they're trying to go into visits positively.
And to your knowledge, now they're only requesting or only agreeing to be drug tested on parent-child visits.
During the family group conference that we held recently with all parties, the parents did say that they were able to swab before or after drug tests and requested that the children not be present for those swabs, obviously. But Ms. Benderly did communicate yesterday that they did have transportation on other days as well now.
Okay, so that should no longer be an issue.
That is my understanding.
Pass the witness, Chairman.
No questions.
Ferris?
No questions, Judge.
Mr. Dunbar?
No questions, Your Honor.
Any other witnesses?
No other witnesses, Judge. Oh, actually, I'd like to call Mr. Kiewit briefly, Judge.
All right. It's 12:27, so let's keep it really brief. Mr.
Yes,
Kiewit,
Representative.
need you to unmute
Yes,
and
sir.
remember that you're under oath.
Yes, sir.
Mr. Kiewit, you heard the concerns about drug testing. Going forward, are you going to drug test for the department?
I'm willing to drug test whenever they need me to drug test. The biggest issue has been transportation. And when I was out of town, I was not working in New Braunfels. I was working in Victoria, Texas area.
Got your narrative.
Sustained.
Okay.
was-
Mr. Kiewit, hold on. They had an objection, so we're
Sorry.
going to move on. As far as your services, are you willing to engage in your services at this time?
I'm willing to do whatever it takes to get the services done. And I apologize. I have mental disorders that I just apologize. And just like, I didn't
Okay.
even talk to the last drug dealio. Like I had phone problems and I didn't even get to talk to the lady.
Okay.
And they
But
dropped-
Mr. Kiewit, you understand that there's concerns about your behaviors with the
I
providers.
understand. I do understand that, and I've tried. I'm working on being better attitude and complying with everything. And I just
And at this time, you have been able to find a ride going forward. Is that correct?
at this time we do have a ride Mondays, Tuesdays, and Thursdays and Fridays due to the fact that the lady that is willing to give us rides has other obligations on Wednesdays.
Okay.
So, but I mean, that's not that people say that they'll help us and then they, I'm trying my hardest, man.
Okay. And are you asking the judge not to cancel the visits with your children?
I'm begging you not to cancel the visits with my children.
Okay. Pass the witness, Judge. Thank you.
Savage.
Mr. Kiewit, you stated you're willing to do anything, so you are agreeing, or are you agreeing that you would submit to a nail drug test if ordered today by the court?
I don't understand why I needed to take any more drug tests into the hair follicle and whatnot. Like, I just wanted.
Objection, non-responsive, Your Honor.
Sustained. Just answer the question that you're asked, Mr. Kiewit.
Mr.
No,
Kiewit,
I don't-
would you
I
take
chew
the nail
my
drug
nails.
test?
I chew my nails. I don't have nails to be able to clip.
Could we get them from your toenails?
I don't understand why I'm being pushed to, like, I've complied with everything other than the fact that I haven't had a ride to be able to get to these drug tests.
I'll pass the witness, Your Honor.
Don't understand.
Ms. Skylar Green.
Thank you, Your Honor. Mr. Kiewit, how do you get to your employment?
I don't have any employment because I lost my job because of this. Because my employer didn't want to come pick me up anymore because the visitations changed and I needed to work more than just a day or two out of town. I ended up losing my job because of this. And now I'm struggling to.
Mr. Kiewit, do you understand that the need for mental health treatment in this case is
I
probably?
do, and I'm trying to get that help. I know I have issues. I don't want them to cause me to lose my kids, so I'm trying.
I have nothing further, Your Honor.
Saris.
No questions, Judge.
Mr. Dunbar.
Mr. Kiewit, have you been diagnosed with a mental health disorder?
Yes, I've been diagnosed with mental health. I've got bipolar and paranoid schizophrenic, and I have social anxiety issues.
And who diagnosed you with those disorders?
When I was back in 2003 and in 2007, I haven't been re-diagnosed since then. That's why I wanted to get re-diagnosed, because I used to get Social Security when I was a kid. When I turned 18, I just asked to be released from it so I could try to be a normal person. And I didn't have issues until just over the last couple of years. I've had some things happen in my life that have just triggered things. And now I'm trying to get that help because I know that I need it. And
do you possess a firearm?
I do not possess a firearm, nor did I ever brandish a firearm towards anybody in this entire case, and I have witnesses to the statement that was put against me at the beginning of this. I never brandished a firearm. I do not have a firearm. I've surrendered my firearm to the state back in February.
Why did you surrender your firearm to the state?
That is because that was part of a stipulation of something that has nothing to do with this.
Well, you're the one that said you
I'm just being honest with you. I'm not like.
So is it your testimony today that when the CPS workers state that you were showing?
I never brandished a firearm towards any CPS caseworker.
Mr. Kiewit, you have to wait for Mr. Dunbar, any of the other attorneys to finish their question before you answer.
I'm sorry.
You know what brandish means?
Yes, sir, I do.
Okay. And so are there any firearms in the house?
No, sir.
A rifle? No pistols?
All my weapons have been removed from my home and given to my father.
When was that?
Back in February.
And when were you initially visited by caseworkers?
Judge, objection relevance.
Well, I'm trying to time frame here.
After my daughter was born.
Hang on, Mr. Kiewit.
Sorry, Your Honor.
Overruled. I'll allow it as far as the time frame pertaining to this firearm issue, but let's stay within that scope, Mr. Dunbar.
Sure.
After my daughter, may I answer Your Honor?
Yes, you may.
Okay. After my daughter was born, I believe her name was Miss Ashley, and another young lady came to our home, and I never possessed a firearm, never brought a firearm out, never even made a comment about a firearm. And that's
so it's your testimony that
my parents were there for this.
Hang on, Mr. Kiewit. I'm going to tell you again.
Sorry, sir.
You got to let Mr. Dunbar ask the question before you start answering it. Go ahead, Mr. Dunbar.
So it's your testimony that the caseworkers lied about you brandishing a firearm?
Yes, sir. And I have witnesses that can vouch for that.
And you're stating that your father is now in possession of your firearms.
Judge, objection asked and answered. Relevance.
Well, what
I'll sustain the asked and answered, overrule the relevance, but let's move it along pretty quick, Mr. Dunbar.
I don't understand why you need to know what kind of firearms.
Mr. Kiewit, you just answer the questions that you're asked. I'll determine whether or not.
My dad, I only own a pistol that my grandfather passed down to me, and 2 hunting rifles that I've had since I was a child.
And would you agree with that? When this case originally started, your parents were supposed to be supervising the children.
Yes.
And they did not follow the safety plan and the supervision rules. And that's why the children were placed with Justin and Kathy Bendelay, correct?
Objection, relevance, Judge.
He's asking us to rely upon the fact that he claims that he's given his weapons to another person, and there's history that the person has not, who he claims he's given
the person in question that was.
Hang on, Mr. Kiewit.
Yes, sir. Sorry,
Mr. Kiewit. I'm going to overrule Mr. Saldivar's objection.
Yes, sir.
And so, previously, your parents ignored the requirements of their duties as outlined in the safety plan, correct?
They I don't even know how to answer this without. My father was present at the home the day in question. He was asleep. He was not.
Objection, non-responsive.
Sustained. I think I've heard what I need to hear. I'm gonna end this line of questioning unless you have something else, Mr. Dunbar, that you think I really need to hear at this point.
No, Judge. Thank you.
Okay.
You know, I have one more question for Mr. Kiewit, if possible.
Yes, ma'am.
Okay.
Mr. Kiva, when was the last time you used methamphetamines?
I haven't used methamphetamine since October of last year.
No further questions.
All right, we're about out of time. Anybody else that you definitely need to call, Mr. Saldivar?
No, Judge, I rest.
Do you have any argument you want to, or does anybody else want to call anybody?
No, Your Honor.
Okay, I'll let you start with argument, Mr. Saldivar.
Judge, as far as my motion, I understand that the parents have found somebody right now to transport on certain days. My concern is that's been the pattern throughout this case, that we do have friends that help occasionally, and sometimes their life interferes with the obligation of giving my client a ride to these services, and then he's getting dinged for not showing up or missing tests. So I'm asking that the department be ordered to transport my client. They've done it before with no issue, Judge. Mr. Kiewit understands the concerns of the department, and he wants to comply with the services and the drug testing. He needs help, Judge. He doesn't have a vehicle. He's struggling with employment at this time for that testimony. So he wants to stay in compliance, and this is a big a roadblock for him to stay in compliance with his services. He's asking the court not to stop the visitation with the children. They've had several visits. They've gone well. There's no physical concerns for abuse at the visitation. You heard testimony that he took redirection well, and he listened, Your Honor. And so this is a process that the parents are going through. They're engaging in their services at this time. Visiting with the children is very important, and I believe if you have to adjust the visitation schedule, maybe making the visits therapeutic, so that the therapist can get involved and maybe fix the concerns that they have with the parents and the children. So cutting the visits off completely, Judge, I don't think it's in the best interest of the children at this time.
Ms. Savage.
Yes, Your Honor. I'd be requesting that the court order the parents to comply with a drug nail test so we can actually get a baseline of these parents' usage. The testimony today is that they've avoided way more tests than they've ever submitted to, that they were demanding to only be tested on certain days, that the days that they said that they could test, then they don't show up. They made it to several visits. They had transportation to get all the way to Victoria, Texas, but they couldn't comply with the drug test. Even at that, they weren't willing to provide any information. So when the parents have control to be compliant and to engage, they just refuse. We had virtual services set up because we understand transportation is an issue. And he gets dropped by 2 separate providers because of his aggression and having to deal with his mental health needs and his diagnosis, which I can understand. But if we do not address the elephant in the room, which is methamphetamine use, we're never going to get anywhere. And we're certainly never going to be able to return these babies back to these parents. This case started because the baby was born meth positive. So that is an issue. So for these parents to be almost halfway through this case and still not doing any kind of drug treatment is a problem. Our goal has now changed to adoption by relative, and that's because these parents are not engaging in anything. These visitations by the children's own therapist is not in their best interest. Their therapist is recommending for these visits to be stopped. It will be more detrimental for the kids to continue to have to go see their parents, for us to terminate their rights in 3 more months if the parents continue doing what they're doing now, which is nothing. Mom's gone to 1 therapy session with her new therapist in the last 2 months, which are virtual, and dad's been dropped from multiple virtual providers. So if we're going to continue on this route, we're not going to be getting reunification, and it's going to continue to expose these children to more emotional trauma than is necessary. So as their ad litem, we need to know what their drug use is. We need the parents to acknowledge that and to work on that. And right now, that's not what we're getting. So I do ask for that nail test to be ordered, and that the court suspend these parents' visits until they get serious about the services. Because if they don't address these issues, the kids are not going home. And I rather be upfront with them right now and tell them that today, where they have time to make changes, than in 4 or 5 months when we're sitting at trial and terminating their rights.
Thank you, Ms. Savage. Ms. Carla Green.
Thank you, Your Honor. At the beginning of this case, I believe it was at the adversary hearing, I asked the court to admonish the parents that this case could either be a case where everyone works together and gets along and engages in services, and we get that goal of family reunification accomplished. what this case has been about, and as evidenced by the testimony of Ms. Palmer, which is, it's difficult. She has to engage with these parents still. She has to see them. And so it's a really difficult position for her to be in this situation where she has to express under oath her personal and professional hesitation and fear in being in a enclosed vehicle driving down the highway with an individual who, Your Honor, in this proceeding alone had to be redirected multiple times by everybody. And I can't in good conscience ask a human being to put themselves in that situation while driving a car. I can't. I wouldn't do it. I wouldn't ask anybody to do that unless there has been some step forward in handling the mental health issue. It's just not happening. And I'm not putting the onus, or I'm requesting the court to not put the onus on a caseworker to drive in a vehicle when, again, through testimony that you heard today, the parents, they get transportation when they need it. It's a convenience issue. If they don't want a drug test, they don't get transportation. If they want to go have some sort of employment that we don't know anything about, they get transportation for that. If they want to see the kids, they get transportation for that, unless it's a drug test that's associated with the visitation, and then they don't get transportation for that. It's too convenient to be really just an issue of not having a car. Everyone in this case, I don't think that's too bold of a statement. Everyone in this case is walking on tiptoes, on eggshells in this case, to not upset the parents. And we're at a point now where we just really need to think about the kids. And that goes from transportation, Your Honor, to the visitation. I do not like being in this position. My caseworkers don't like being in this position of having to change a permanency goal this much into a case. But we have to think about now what has been accomplished, what we've figured out in this case, what services have been attended to. Maybe drug use is being used as a fix, as a Band-Aid for mental health issues. We'll never know unless we get something accomplished. It's not being accomplished because I firmly believe, and the evidence has shown, I just think Mr. Kiewit, his go-to is to fight. It is to get up and walk away. It is to yell. It is to harass. It is to get angry. It is to get personal. And it is to be defensive and attack anybody who crosses him, including his children. There is now, as per the therapist notes, there is significant concerns as domestic violence in the home. We don't suspend visits because there might be domestic violence that occurs at a visit. That's why they're supervised. That doesn't happen very often. The concern is that these children have experienced or witnessed domestic violence, and we are going to subject them to that individual who committed that domestic violence when there has been nothing that's been addressed. When a therapist says this, that's taken as gospel. That's the expert in the room. And so it is not something that we enjoy doing. It's not something that we do willy-nilly, but at this point in this case, with all of the concerns that we know about and a therapist recommendation that these kids are potentially going to be harmed by this sort of interaction with their parents when nothing has been addressed, that's why we're asking to suspend it until we can actually get out of this cycle where Mr. Kiewit and Ms. Benedict blame everybody else for their issues and we get it addressed. Thank you.
Thank you, Ms. Kyler Green. Ms. Harris.
I'm sorry, Your Honor, I was on mute. There's been no testimony or evidence that Ms. Bendeley has been aggressive or violent in any way that should prevent Belong from providing her transportation when it's needed or allowing her to have visits with her children. I understand that they are working this together, that Ms. Bendeley has exercised some visitation by herself with the children, and she should be allowed to continue doing so even if your decision is to suspend Mr. Kiewit's visits. Additionally, I think it's fair for Belong to provide her with transportation. It's not fair to say that they only miss drug tests because of transportation issues. They have missed visits because of transportation issues. Yes, they need to work services. Yes, they've got a lot of work to do. But Belong can't just say, here's a list, go get it done. I think that it's very evident from the testimony today that this case is going to need some kind of additional hands-on help to be able to get these parents where they need to be able to get back to their children.
Mr. Dunbar.
Yes, Your Honor. As I sit here, I think about accountability, and the parents need to be held accountable what I'm hearing from the parents, it's about, oh, woe is me, I. You never are they concerned about what's in the best interest of the children, Your Honor. And the court needs to be punitive to their behavior. The court should not reward these parents for their bad behaviors. The court needs to take control of them, and we support the motions to suspend the visitations and to progress elevate the drug testing on these people. They've shown a disregard for the processes. They should not be rewarded for it. At the same time, this is doing harm. It's not in the best interest of the children to continue to be forced into these situations with these persons who it appears that they've already expressed that they want less contact with their parents. And, as a side note, while Justin and Kathy Bendelay are, grateful and happy to participate in this case, and their ultimate goal is to adopt these children also. But we do have to take into consideration, Your Honor, they do have a family, they have other children too. And these, especially missed appointments, are disruptive to them and to their children also, Your Honor. But I think if we were to do anything, these parents are not deserving, Your Honor. It's one thing if they were working services and they were at the minimus, doing the minimus. They're not even doing that, Your Honor. And so to continue to reward these parents, it sends the wrong message, Your Honor.
Thank you, Mr. Dunbar. I'll give Mr. Saldivar 1 minute and Ms. Savage 1 minute of rebuttal.
Judge, I think it's imperative that the court recognize that the parents have been trying with the resources that they have to engage in services. They do live out in the country, and Wi-Fi is not the best. You can see that the parents are not at home. They have to travel to have steady Wi-Fi, Judge. And the transportation is a real issue in this case. And that's prevented the parents from engaging in services. You've heard Mr. Kiewit, he understands the concerns. He's going to drug test for the department. This is something that he's been struggling with, and he's willing to do that for the court. But to cut off visits, it shouldn't be used as a punishment to punish the parents for not complying 100% in services, Judge. This is to continue the bond with the parents. They're not terminated. They still have parental rights to these children, Judge. They want to visit with their children, continue bonding while they make progress in their services, Judge.
Ms. Savage.
Your Honor, the testimony and the recommendation from the children's therapist is that these visits are harmful to the kids. It's harmful to their emotional development. When the parents are missing visits, that is harmful to the kids. When the parents come to visit and Mr. Kiewit is making outlandish statements that the interveners are trying to take his kids away and getting aggressive with the supervisor who's hearing the phone calls, it's harmful to the kids. So it's not punitive on these parents. However, these parents have not made any progress that would result in reunification. They're not trying. Mr. Kiewit's drop from OSAR, the virtual provider, or from his outpatient program, wasn't because he didn't have good Wi-Fi. It was because, again, he got aggressive with two separate providers and they've dropped him from their program. Ms. Bendeley hasn't even bothered to try. So no, they're not making progress. They're not making any kind of good faith effort. And it's more harmful to these kids to keep dragging them through this process than if we just end these supervised visits now.
I'll hear from CASA and then I'll make a ruling.
Your Honor, CASA volunteer Pete Pentez has visited the children in the home and taken them out. They're doing very well. They enjoy where they're living. We believe it is in their best interest that they remain in that placement. CASA is concerned that the parents use the excuse of no transportation when it suits them to avoid drug testing. We would be in favor of a nail-bed drug test, and in CASA's opinion, if positive, they should be ordered to inpatient drug treatment. We also agree that based on the therapist's recommendation, visits should be suspended at this time until the parents are in full compliance with the service plan.
Thank you. As to Mr. Saldivar's motion for transportation, that is denied. As to Ms. Savage's motion to suspend visits, that is granted. I'm going to order that the parents submit to a nail bed test by 5 o'clock Monday afternoon. I'm going to order that Belong provide the results of the nail bed test to all parties in the court as soon as they are received. And then once the court receives the results, after all the other parties have had a chance to review them, I'm going to set a progress hearing, and then we'll talk some more about this case. I have serious issues with the credibility of Mr. Keevitt. I have serious issues with the fact that neither parent seems to be taking this case seriously, and I think all of that stems from continued drug use. It's hard to find a person credible, and it's hard to engage in anything if you're continuing to use. And the evidence here has shown today, seems to be very clear, that the issue of the transportation is being used as a crutch to continue to use drugs. It is being used as a crutch to avoid, as Mr. Dombart said, accountability. Suspending the visits is not punitive. I'm concerned about these people being around children. I'm concerned. Brantley's 10 years old, and Remington's right behind him. You know, they're old enough to know. They're old enough to see that something's not right. And I think the therapist's recommendation, you know, obviously that holds a lot of weight, but this is about the best interest of children. And at this point in time, I don't think the children are benefiting from these visits. I think they're being harmed by them. So I'll make further orders if I need to once I receive those results. But at this point in time, no more visits, and the parents need to figure out what they want to do in this case. And Ms. Kyler Green is correct. I did admonish these parents back on July the 14th, specifically the fact that I made a note that Mr. Keevitt at that time, 2+ months ago, felt like he was being outed and attacked, and that's in quotes, by the department. And I said I wouldn't increase any visitation until the parents engaged in services. We're here 2.5 months later and nothing's changed. So those will be my orders. Mr. Saldivar and Ms. Savage, you get together and decide if y'all want to create one order for both motions, or if you each want to create your own order. Please circulate, or you don't need to circulate it. You just need to send it to me for signature. And as far as a progress hearing, we're going to wait till we get the results. I'm going to obey that part of my order. That'll be the order of the court.
Judge,
thank you all for your time and your service. Yes.
Judge, if I may, I believe we're still set for October 20th, though, correct? I believe it's the 20th.
We have a hearing October the 13th.
Okay.
No, Your Honor, that's been moved.
That's been moved to the 20th. You're correct. You're correct. If we need to take it up on that day, we will. But if there's something more concerning to me, I might set something sooner on an emergency basis.
Yes, sir.
All right. Any other clarifications? Not any other relief. Any other clarifications?
No,
Just clarifying, Your Honor, this includes the virtual visits as well?
Correct.
Thank you.
Okay. All parties are excused. Thank you. Have a good weekend.